Thank you, Mr. Speaker. To debate the bill.
The lady has the floor.
Thank you. So I just want to really appreciate some of the sentiments that have already come forward about the responsibility and where the buck stops with regards to paying for special education. And I think there are some people in here who believe that Idaho could somehow lower these costs, or that we could refuse services to some of these high needs students. And I want to be very clear that the law that provides for these services is still going to apply, no matter what happens at the federal level or here at the state level. And so I just wanted to talk a little bit about that law as somebody that deals with it quite often. So the law is called the Individuals with Disability Education Act, right, IDEA. And as educators, we call this the Students with Disabilities Bill of Rights. And I just want to talk about a couple of those and the cases that have been brought before the Supreme Court recently to uphold those time and time again. Number one, a free, appropriate public education, FAPE is what we call it, is one of these Bill of Rights, that the schools must provide education at no cost to the parents. Education must actually help the student learn and progress. Now, the Supreme Court has, since 1988, upheld FAPE over and over again, the first ruling being Board of Education versus Rowley. Number two, mandate to find. And this is an important one. Schools must actively look for students who might need special education services. They cannot wait until a parent brings it to them, and they must evaluate students once they are found, and they must include students in private schools and homeschoolers. So in 2009, the Supreme Court ruled in a case in which a young man was not evaluated by the public school and the parents took him to a private school, that the state, as the obligatory entity and the local school district as the provider of the services, was in fact on the hook for those costs. And in this state today, because that has been upheld multiple times since 2009, we pay special needs services to our students in private schools and homeschools. Number three, the IEP, the Individual Education Plan. Every eligible student gets their own plan. It's like a roadmap for students. And in 2017, the Supreme Court in Idaho versus Douglas County School District even broadened that to say that IEPs have to be ambitious and challenging for every student that receives them. Ambitious and challenging. So to the point about Mr. Mason, who testified from Twin Falls about a student who was in a residential care facility, that residential care facility falls under the Supreme Court decision of Idaho versus Douglas County School District. This is the eligibility, the individualized education plan that is provided to that student no matter. Number four, also on that topic, the least restrictive environment. It has been deemed time and time again that the best thing for our students is to be in a least restrictive environment. Students should be with their peers as much as possible. A school must justify removal from a regular classroom, and support services must go to the student when possible. So to the ASL virtual, it may come down to a court case. As a parent, I may have a problem with that if I don't feel that my IDEA rights are being met for my student. Olmstead versus LC went further and said that students not only need LREs when they're in school, but also outside of school. And then in a 1999 decision, Cedar Rapids versus Garnet F requires schools to provide any necessary medical services needed for a student to attend school as much as humanly possible. This too has been upheld multiple times. 5, parent rights. Parents are equal as a team member in a child's special needs learning. They must give permission, and they can challenge school decisions. In 2017, in a case, Fry versus Napoleon Community Schools, it gave specific authority to parents to sue LEAs. Those are those local entities of which the state education agency, in our case that would be the Idaho State Board of Education, is the obligatory party. So anytime a parent feels they are not having the needs met under that federal law, IDEA, they have the right to sue, and it is that state entity that is on the hook for it. Number 6, the transition planning. We must create a plan for a meaningful life after school. It must include college, work, or independent living goals, and it must involve the student in the planning. These are the basic rights for students with disabilities. They are as fundamental as the Bill of Rights for the broader American public. And so for clarity on who's going to be on the hook for expenses for public education, IDEA mandates that each state designate one entity in order to make sure that all of this happens in accordance with the law, and that other entities can help deliver those services, but that one entity is on the hook for it. And that is, in Idaho, the state education, right? The Idaho State Department of Education. And so we must continue to fund our special needs communities, because we really only have two choices. We can either fund special education, or we can fund special education and lawsuits. Those are our two choices. The Supreme Court has devolved a lot of its power over the last 30 years back to the states. In this specific instance, every single time the Supreme Court and the federal courts have maintained their supremacy over what is good for our children with disabilities. And they will continue to do so no matter what happens at the federal level, and our parents will demand such of us. And so I urge you to help make sure that we have the money available for when our special needs population not only needs this money, but when our parents demand it of us.
Further debate on the motion. Goodlay from 2.
Thank you, Mr. Speaker, to debate.
Goodlay has the floor.
Thank you. I just wanted to say that was the best testimony I think I've heard on this floor in 11 years. Very well said. And I learned so much from what you just shared that I had no idea about. That being said, I think we can find the funding from somewhere else. I'm not going to vote for this, but those are real problems that we're going to deal with in our schools. And I was very unaware, and I just wanted to compliment the good lady for her testimony.